What up?
Oh,
Hello, and welcome to the Ohio Estate Planning Secrets Seminar. Tonight, we're going to be talking about the ins and outs of probate court. I'm attorney Edward Littlejohn, the founding attorney and CEO at Littlejohn Law. And tonight, I have the probate paralegal, Natalie Kuchera, who's going to help me discuss the ins and outs of probate. Natalie, welcome aboard tonight. This is going to be an exciting one where, like I said, we're going to be going over the ins and outs of probate. I want to share with you guys a quick video. If you are in the Facebook group, I'll add the video to the link. But if you are live and in the seminar, you can watch this video briefly, um, just going over a little bit about who I am.
Expectations and provide high quality legal services. We are honored to present this attorney with the Elite Lawyer Award. By demonstrating legal proficiency, achieving recognition from their peers, and upholding the highest ethical standards, they have rightfully earned a spot in our exclusive directory and the prestigious title of Elite Lawyer.
All right, if you're watching this on Facebook, you might not be able to see that, but this year I was acknowledged as an elite lawyer for 2025. This is my third year in a row of becoming an elite lawyer for real estate and probate matters. And so tonight we're going to be going over kind of the ins and outs of probate court and kind of what you can do to protect your family to avoid the probate court process. So the first thing is if you guys have any questions, feel free to put the questions in the chat. And then we're going to open it up at the end. We're going to open it up to questions. So if you guys have any questions, you'll be able to ask those questions. And then either myself or probate paralegal Natalie Kuchera will be able to provide the answers to you. So, like I said, tonight we're going to be focusing on the ins and outs of probate. And so, Natalie and I have handled tons of probate cases together. In fact, Natalie, for the past over 2 years, she's worked exclusively in the area of probate here at Littlejohn Law for the past year, 2 years at the Franklin County Probate Court. So, Natalie has a wealth of knowledge as it relates to probate. And so tonight, like I said, the first thing that we're going to talk about when it comes to probate is understanding what probate is in general. And so one of the things that I like to explain to people is that probate is the process, the legal process by which we take the assets of your loved one and transfer them to the appropriate person. Okay. And that's the simplest way to put it is take the assets of the deceased and transfer it to your loved ones. So one of the very first steps that we have in our probate framework is we gather initial information. Now, it seems like that would be simple enough, but Natalie can tell you how many cases that we've worked on where it's just been very difficult to do a couple things that seem like it would be easy. Number one, identifying the next of kin. Natalie, can you talk a little bit about, the next of kin and who that is when it comes to the probate process?
Sure. So the next of kin is the closest living relatives to the deceased party. So whether that's a surviving spouse, if you and the surviving spouse have children, that would be your children. If there are no children, then you would look to parents. If the parents are deceased, you would then look to either some grandparents, whether there's cousins, you just kind of keep going down until you find the closest relatives.
Right. And like Natalie says, it's kind of like a process that we do with the probate court to identify that next of kin. So one of the first things that we recommend that you do is locate a will, because if there's a will, then it will identify who's supposed to inherit. And as Natalie said, it's the next living loved one who may inherit if there's no will. And what we do is that's called the intestate succession process. And so it's the process that the probate court follows to kind of create a family tree. And then once the probate court creates the family tree, they identify who the people are and if they're legally entitled to inherit. Now, the next thing, as we're gathering this essential information, one of the things that we always talk to clients about are the distinction between probate assets and non-probate assets. Now, the easiest way for me to explain it is a probate asset is any asset that would require the deceased signature to transfer that asset. So if my car's in my name only and I pass away, I'm not here to sign the title. If my home's in my name only and I'm not here, or if I pass away and I'm not here to sign the title, that's going to be considered a probate asset. And the reason why we designate it as a probate asset is because the probate court has to execute a new title. The probate court has to issue a new deed to the property to transfer that property to our loved ones. So with that is the opposite, which are the non-probate assets. Now, non-probate assets are assets that transfer as a matter of law. The most common non-probate asset that Natalie and I see are life insurance policies or some sort of IRA or retirement account that has a beneficiary. Natalie, are there any other common non-probate assets that we see?
Another common one is a bank account. If the decedent person who died had a surviving spouse and they're on the account, or one of their children's on the account, then that would be a non-probate asset. The other person on the account would just have to show a death certificate and get the name removed from the account, and then that's how they would get those funds. So that's the other common one that we see.
It's a great point that Natalie brought up there, that there's some assets that are probate assets that can be non-probate asset, but it comes down to how they're titled. And as Natalie just said, if there's a bank account that's in the deceased name only, that's a probate bank account. But if there's a bank account that's owned jointly by, say, a husband and wife or a parent and child, that becomes a non-probate asset and it transfers automatically as a matter of law. So the next thing that we're doing while we're still in our first step is we want to see if we can locate a will. Now, one of the things that you have to understand is under Ohio law, an original will is required. So the probate court has a proceeding to admit a copy of the will, but you need the original will to facilitate probate. So one of the things that we'll try to help you do is if you drop off a box of documents, I know Natalie and I go through the documents to separate which documents are relevant to the case, which documents aren't relevant to the case. Shout out to Lainey Gill, because she helps out with that process as well. Shout out to Lainey. All right, Natalie, you want to talk a little bit about the liability for fiduciaries, because a lot of times people think, hey, my loved one passed away, I get control of everything, or my loved one passed away. Are there certain responsibilities that you have if you're going to be an executor or an administrator as it relates to an estate?
Yeah, so being a fiduciary is a really big deal. You're essentially handling the assets of someone who's passed away and making sure they get to where the decedent wanted them to go or where they need to go under the intestacy statutes. So the first thing that you kind of want to do is, find those assets, you want to safeguard them. Some clients will rent out storage units to make sure it's safeguarded. Some will move things to their house. That's one of the first things. You want to protect the assets that you do have. You have a duty to handle every item with care, especially estate funds. Anytime you're handling money, it's very closely watched by the probate court. They want to ensure that the money is safe and it ends up going to where it needs to go. So you have a lot of duty and responsibility as the fiduciary to make sure that all the assets that the deceased person has gets to where they need to go.
Right. And I think that's a great segue in kind of the next step. So if you think you were either identified in a will to be the executor and kind of in charge of everything, or you're taking on that responsibility, like we said, the very first thing is you want to see if you can locate a will. If you can't locate a will, you're going to want to start gathering essential information, like identifying the next of kin, who you think are the next of kin, and then you're going to want to find out how the assets are titled. Like I said, we're going to look for deeds, we're going to look for bank accounts, We're going to look for IRAs, 401ks, any different retirement accounts. Now, once you have that information at your fingertips, the next step is what we call the pre-filing steps for probate success. Now, if you're in the pre-filing phase for probate, that means you've already identified the next of kin, you've identified the assets, and now you're in a position where you can do three critical things. The first thing that you're going to be able to do is determine the value of the estate. Here in Ohio, we have two main processes for administering the estate. The first is what we call a full administration, and the second is what we call a release. Now, the release of administration has very specific requirements. And generally speaking, one of the most common releases of administration that we do are all the assets are $35,000 or less, and they're going to the heirs. Now, there are some other situations where you can perform a release, such as $100,000 or less of assets, and there's a will leaving everything to the surviving spouse, or there's a small estate, you could perform a release. But the most common one that we see is a release where it's $35,000 or less. Now, if you don't qualify for the release, you're going to do a full administration. Now, one of the things that we get from time to time is people will say, hey, the home is worth $150,000, but we still owe $149,000. Does that mean that $1,000 of equity constitutes money towards a release? And the answer is no. The way the value works for determining the estate is we're going to look at the actual value of the property. And typically we use the auditor's value. So Natalie's worked with me on cases where we use the auditor's value for the real estate. She's located commissioners or appraisers to appraise personal property. I know one of the cases that Natalie just recently worked on, they had to appraise farm equipment and other items, right, Natalie? And so the person that we get to do the appraisal has to be appointed by the probate court. The next thing that we have to do is, so we're gathering information about what we believe the assets will be. And then we're also identifying if we'll have to post a bond. Now, under Ohio law, anytime the assets are more than $10,000 of liquid assets, you're going to have to post a bond. And typically the bond is 2 times the value of the liquid assets. So let's say there is $50,000 in a bank account. You're going to have to post a bond in the amount of $100,000. Natalie, you want to talk a little bit about the bond requirements?
Sure. So the bond is essentially like an insurance policy on the assets, making sure that the fiduciary is going to fulfill their duties as an executor administrator of the court. So there's a few different ways that you can post bond. If there's a will and you're nominated as executor, and the will could waive the bond, so you wouldn't have to worry about getting bond. If there is no will and you're going to be applying as administrator, you will have to apply, you will have to post bond. So there's an application that we use with an insurance company here, and it goes over just a little bit of your financial information. You get a little more of your contact information, and make sure that you're able to get posted bond. So you will be required to pay a premium fee, which is essentially just like a small percentage of the amount that you'll be required to post. I know that's a big issue with our clients. They're not wanting to post a bond, they're not understanding it. So that's just something we like to go discuss up front.
Right. And like Natalie said, if there's a will, then you don't have to post a bond. Most wills will say no bonds required. And so if there is a will, you won't have to post a bond. But if there's no will, then you're definitely going to have to post a bond. The other thing that we know as it relates to bonds, if your administrator or the person that you want to be your administrator or executor of your estate resides outside of the state of Ohio, even if your will says no bond is required, the probate court will require them to post a bond because they are not a resident of this state. So the last thing that we focus on when we're in our pre-filing phase are our bills and creditors. And so often people say, well, hey, we have all these bills, or I paid for the funeral bill. I paid for this. I paid for that. We've been getting medical bills coming to us. Do we have to pay the bills? Now, here's what I always tell people when it comes to the bills. Under Ohio law, creditors have 6 months to make a claim against an estate. Now, there's a very specific way for creditors to make a claim against the estate. And if they fail to make a claim against the estate in the proper manner, then they're not legally entitled to any reimbursement. Now, what we see very often are loved ones decide, hey, I want to pay any claims, right? I get a medical bill, I'm going to pay it. That was my wife's bill, I'm going to pay it. And so as a result of that, they will pay the bills, even though the bills have not been approved to be paid by the probate court. So just to recap this step, we have determined the value of the estate. We know if we're going to need a bond or not. And again, if there's no will, you're definitely going to need to post a bond. And then you've identified some of the creditors. Now, most of the cases that Natalie and I work on, we will wait 6 months before we open up the estate so that we can minimize the debt on the estate. If there are creditors, if there are credit card debt, if there's any unsecured debt, we're going to wait that 6 month period so that we don't have to pay those creditors. Now, if the debt is secured debt, then whether it goes through probate or not, those creditors have a priority claim on the assets. So a mortgage or a lien on a car, those claims are priority. And so if you want to keep the house or you want to keep the car, then you're definitely going to need to make the payments. So I think at this point, Natalie, let me see if there's any questions in the chat. Are there any questions in the chat out there? If you have a question, we're right at the point where we're almost ready to open up an estate. Okay. Not seeing any questions in the chat. If you do have a question, feel free to put it in the chat or unmute yourself and ask your question. Feel free to unmute yourself and ask the question. Okay. All right, so we're going to move into the next part, which is opening up the estate. So now that we've identified, yep, I see we have a question coming in.
Say no and be no.
Hello? Looks like we have a question coming in. You have a question there? No? No, I'm going to go ahead and put you back on mute. If you do have a question, feel free to mute and ask your question.
Name's Rick Kirby of the Creek Pump.
Okay, so now we're at a point where we're ready to open up the estate. At this point, since we're ready to open up the estate, we have prepared all the necessary documents that need to be submitted to the probate court. We've obtained the filing fee. Here in Ohio, the filing fee ranges anywhere from $250 up to $350 to open up the estate for full administration. Once everything is submitted to the probate court, we'll be at a position where the probate court can give us what's called a letter of authority. Now, I always call the letter of authority a magic key because it gives us access to anything and everything that we have. Natalie, you want to tell us a little bit about the letter of authority and how the probate court, what the process that they go through to approve somebody to issue a letter of authority?
Sure. So if there is a will nominating an executor, that's typically the person who is filing the application. The court will look to the will and see if the person applying is the person who's nominated. If they're nominated as an alternate and the person who they nominated first was unable or unwilling to serve, then they'll look at that alternate and see if that matches. If the person is still alive and they were nominated, then they could sign what is called a waiver of right to administer, essentially saying, I acknowledge that I was nominated to serve and I am declining to serve in this role in favor of someone else. If there is not a will, like we said before, if you're in a higher resident, you can apply to serve. There is like a hierarchy of who the court looks to first. Typically, that's the surviving spouse. If there is no surviving spouse, then if you had multiple children, they would be next in line to serve as administrator. And if one of them wants to serve, then you would obtain the same waiver of right to administer from the other siblings. If there's no other children, then it could be a family member, it could be a family friend, that the court will look to and see if you're a suitable candidate to serve. Then the court will issue a letter of authority, which has your name on it. It lists that you have authority to act on behalf of the estate. So the letter of authority gives you permission to act as a fiduciary of the estate. So this is typically when, if you were unable to identify assets, you could take the letter of authority to the bank and you would be able to see if they had an account there, what was in the account. You can talk to insurance companies, life insurance companies. Typically, they will not speak to you unless you have authority to act on behalf of the estate before they release information to you.
Well, thank you for that, Natalie. And like Natalie said, once you get that letter of authority, you'll be able to go to the bank. You'll be able to access, anything that you didn't have access to. In fact, there are a lot of responsibilities that you have, and I'm just going to read off a few of them. Number one is you're going to notify any beneficiaries and heirs within 2 weeks of the notice of the certificate of probating a will. The next things you're going to do, you're going to make and file an inventory of all real and personal property within 3 months after the court has granted you your letter of authority. Number four, you are going to deposit any funds into an estate account. Number five, you're going to keep the estate funds separate from all of your funds. The next one, invest all funds in a lawful manner. And then you're going to file a final account and distributive account within 6 months after the appointment. And last, if necessary, you're going to file a final tax return or any tax documents. Now, one of the things that we see often are we will assist in allowing the executor or an administrator to open up an estate account. Now, the estate account are assets that belong to the heirs. And so far too often we see people who have that magic key, the letter of authority, use estate funds improperly, which is why the probate court requires a bond. Natalie and I have worked on a case where people have used estate funds to go to the casino. They've used estate funds to pay for veterinarian services, right? They used the state funds for things that truly were not related to the estate. And that's going to get us into a problem. We'll talk a little bit about that towards the end, but the estate account should be used for estate funds and estate bills only. And again, remember, the creditors don't have a legal right to reimbursement until the probate court approves a claim. Okay, so if there's a creditor out there that wants paid, they don't have a legal right until the probate court approves it. Natalie and I worked on a case, and Natalie's doing a great job of bringing it to conclusion, where a client, the estate got opened up. Next thing you know, there's these creditors, credit card companies are making a claim. I think one was 9,000, another one was 5,000 or 4 or 5,000, and Natalie was able to assist in negotiating that claim down to a lesser amount, so that the family could have satisfied it. Now, the two things happened. The creditors made the claim, but then the probate court had to approve the claim to say, hey, this is a valid claim and they are legally entitled to the money. The next thing that we do is what's called an inventory and appraisal. Now, again, once you have that letter of authority, you can go around, access all of the assets, and then you have to submit an inventory to the probate court. Natalie, you want to talk a little bit about that inventory and appraisal that we submit to the probate court? Because before, when we were identifying the assets and determining the value, we really didn't know what the value of the estate is. But now that we have our magic key, we're in a position to know. You want to talk a little bit about that?
Sure. So when I go to prepare a inventory, the executor administrator is very crucial at this point because they're the ones who are actually going out with that letter of authority to the bank, to any retirement agency, if you have an IRA, if you have stocks, if you have bonds, and are really getting that information. So while we don't need to know how much is in a bank account at the time the estate is open, we can put a general number on the application. At the inventory, exact values are needed. So the exact number in a bank account, or if an item needed appraised, such as right now we're doing one where there's a lot of Harley Davidson memorabilia. That's something that doesn't have a readily ascertainable value. So it was something that we need to get an appraiser to go ahead out and see how much that asset is really worth and give a value for it. So on the final, on the inventory, we will put the exact amount of the asset. We'll usually submit a bank account showing that the numbers match. If there's a check from an IRA or life insurance, we'll attach that to the inventory as well. So we do have to have the exact amounts and some sort of statement or a check to accompany that amount as well to submit to the court.
Okay, and to Natalie's point, once we submit all of that to the probate court and we identify the specific assets and we identify the values, one of the things that we see very often are family members contest or challenge the inventory. And so what we mean by this is they read over that inventory and they say, hey, there's some assets that are missing that my mom or dad had or my loved one had. I know Natalie's working on a case right now where there were some trailers, and the trailers were supposedly not probate assets, and they were removed from the property. But there's a title to the trailer. The title's in the name of the deceased. So we know that it's a probate asset, so it needs to be returned so it can be added on the inventory. Once the inventory and we have the appraisal completed, the probate court typically will approve the inventory. Once the probate court approves the inventory, we can be in a position where we're ready for what Natalie and I call strategic planning for asset distribution, right? So we're like at a place where we're ready to talk about what's the game plan for distribution. Now, here's what I'll say. If there's a will, there's a way. If there's no will, then there's probate. And what I mean by that is if the will says I want to give 5% to this person, 10% to this person, 20% to this person, then that's exactly what will happen. But if there's no will, then the probate court will identify the parties and convey the assets to the parties based on the law. So let me give you an example. If there's no will and there's surviving spouse, and the surviving spouse is not the natural parent of the minor children or the children, then the surviving spouse gets the first 20,000, and then the remainder is split 50-50 amongst the children and the surviving spouse. But if the surviving spouse is the natural parent, then that number is increased to 60,000, and the surviving spouse is entitled to, Natalie, correct me if I'm wrong, is it 2/3 or 1/3 of the remaining estate?
I believe it's 2/3.
2/3, just by being the surviving spouse and one parent of one of the children, 2/3 of the estate. And then the 1/3 is split amongst the other children. So when we're at this next phase, we're kind of identifying, like, we know who's supposed to inherit, but we're not sure specifically what assets they're going to have. I know Natalie's working on a case right now where it's that exact fact pattern where the surviving spouse is not the natural parent of the two children. And the two children want to purchase the home, they want to purchase vehicles. And so there's no will. So the probate court is going to divide it up in the first 20,000 is going to go to the surviving spouse. The balance is going to go to the children. And so we're kind of in a place where we're putting a plan together to make sure who's going to get what. And Natalie's role in this is she normally helps me with preparing an accounting and identifying claims that we might need to pay. Now, it does look like we have a few questions in the comments here. So let me bring a question up, Nat. All right, the first question is, if an adult died without a will and had no assets, but there's a pending medical malpractice lawsuit, why would there need to be the need to open up an estate? That's a great question. So if someone passes away, like we said at the beginning, the only person that can act on behalf of the deceased is someone who's appointed as an administrator or an executor of their estate. So in this question, they're saying, hey, there's a pending medical malpractice case. The only person who could file that lawsuit is the deceased, and they're gone. So the next person is someone who's been approved by the probate court. They would be able to file the lawsuit on behalf of the deceased. And so without that estate being opened up, nobody can legally file on behalf of the estate. Great question. All right. So, Natalie, anything else you want to talk about as it relates to the strategic plan for asset distribution and kind of getting the accounting together?
No, I don't think so. If anyone has questions about that, please feel free to ask a question.
Okay. So now, like I said, we're at the point where we're like, hey, we're ready to distribute the assets. Now you have to prepare an accounting, right? Now the accounting is the process by which you account for every single penny that was in the estate. One of the things that we look for in the accounting while we're doing the accounting are any receipts, any canceled checks, bank statements, because we have to calculate this all the way down to the penny. Natalie, you want to talk a little bit about the accounting there?
Sure. So something that we do for the final accounting is the estate account, which is opened once someone receives their letters of authority and they have the authority to act on behalf of the estate. What we will do is open a estate account with any bank. It could be where the deceased had their financial accounts, or it can be any bank of your choosing. And essentially what that functions as is any money that comes into the estate, whether that's something from, whether you have two bank accounts, all the funds from that bank account are going to go into the separate estate account. And only you as fiduciary of the estate have the authority to withdraw funds from that estate. So we talk a little bit about spending from the estate account, what are legitimate expenses, what are not. A lot of legitimate expenses that we typically see is paying property taxes, paying any utility bills, insurance. Some other things we've seen was to cover the filing fees for the court, attorney fees, that could be withdrawn from the account as well. And what we do with the final account is we account for every deposit that goes into the estate account and any money that's withdrawn. So like Attorney Littlejohn said, if a check is written, say it's for property taxes, we want to see that check, whether it's a photo of the check, whether it's a canceled check that appears on the statement. We just need to show the court that that money came into the account and it also left the account and what it was for. Because the court will go through and line up every penny that was deducted, and if it doesn't match, then there will be an issue. So we want to have all these receipts to be able to show the court, here's the money that came in and this is where it went.
All right. In addition to that, like Natalie said, we're going to show here's the money that came in, here's where it went. We submit that to the probate court. If you disagree with how the money was handled, right, you can file objections to the accounting, right? Now, objections are typically in probate, we have a lot of paper hearings, what we call paper hearing, where it's really a deadline, but you need to file the objections by the deadline, and then the probate court will set it down for an official hearing. Also, when we're at this phase, we're going to be preparing receipts to state, hey, so-and-so received X amount of dollars, or an assignment or a disclaimer. Now, an assignment and a disclaimer is where you may have a legal right to an asset, and you're saying, I don't want to receive that asset because of whatever reason. Natalie and I worked on a case where a client had a legal right to receive a third of a piece of property, and everybody signed disclaimers so that the real estate went to one person instead of another person. Okay. Now, once all of this is done and the probate court approves everything, the inventory, then the probate court will issue an entry discharging the administrator or an executor of the estate. Now, this entry will close out the estate. Now, typically, in order for the probate court to do that, they're going to want to see a calculation of the attorney fees. They're going to want to see a calculation of any fiduciary fees, and they're going to want the beneficiaries to sign off on that accounting. If they don't sign off on the accounting and the accounting, then the probate court will set the matter down for a hearing, and then everybody will have until that hearing to object, or the probate court will approve the accounting. Now, let's talk about the cost of probate. Now, one of the many little known facts are an estate roughly valued at $250,000 could cost your family about $18,000 in administrative fees. Now, here's how it works. And under Ohio law, there is a specific statute that deals with fiduciary fees as it relates to executors, administrators, and attorneys' fees. Now, the way that statute works is the first $100,000 of estate assets, you're entitled to 4% of that. And then the next amount up from 101 up to 400,000, you're entitled to 3% of that. And anything from 401,000 beyond, you're entitled to 2%. So if you take a fiduciary fee of 4% of 100,000, that is $4,000. And then 3% of 150,000 is another $4,500. That's $9,000 just as an executor fee or an administrator fee. And typically the attorney fee models that same process. So that would be $9,000 to the executor and then another $9,000 to the attorney. And again, this is something that would have to be laid out on the accounting and approved by the probate court. So that $9,000 to the executor and $9,000 to the attorney, that's $18,000 plus the probate filing fee, maybe the bond. You may be looking at almost $20,000 for an estate that was worth $250,000. Now, why Natalie and I both enjoy, maybe I enjoy it a little bit more than Natalie does, enjoy the going through probate. One of the things that we try to help people do is avoid probate altogether. And in a second, I'm going to talk about why going to probate is actually failed estate planning. But it looks like we have a few more questions down in the chat, Natalie. All right. So how does life insurance proceeds work, especially if there is a named beneficiary? Does it go through probate court? Great question. So life insurance, like I said at the beginning, we're identifying probate versus non-probate assets. And so that life insurance policy would be considered a non-probate asset. And as a result of that, it would avoid the probate court altogether by being a non-probate asset. Now, one of the things that Natalie and I have seen over the years are situations where a husband and a wife designate each other to be their beneficiaries of a life insurance policy, but they don't designate a contingent beneficiary, which is a beneficiary outside of the primary beneficiary. So we call it like a secondary beneficiary. And so when that happens, if there is no contingent beneficiary, then it goes to the estate. Natalie, you want to talk a little bit about that?
Sure. So if one of the spouses passed it and the names the other spouse who's also passed as a beneficiary, we would need to open an estate for the beneficiary spouse and have the check written to them and have it go through their estate. And so then it would be probated either through their will, or if they didn't have a will, the intestate laws. So their children or whatever family member is the closest. That's how we would get around that one.
Okay, great. Looks like there's another question. If there's a joint account, does it still go through probate? No, that's also considered a non-probate asset. And that's the perfect segue into, there's 4 things that you should do right now to make sure that your estate avoids probate. Number 1, you should go and look at all of your assets and see how they're titled. If you have a home, is it titled in survivorship? If you have a bank account, let's make it a joint bank account. Or you can make it what we call payable on death, which means it's payable on death to this particular loved one. And all they have to do is present a death certificate. The next thing, your vehicle, make it TOD, which stands for transfer on death. By making it transfer on death, it too avoids probate. All someone would have to do is go to the BMV or the title office and give them a copy of your death certificate, and they would issue a new title in the name of the deceased. So those are the 3 things that you should do right now. Now, The four critical documents that you should have are a will, a living trust or Medicaid asset protection trust, and a healthcare and financial power of attorney. Now, Natalie's worked on several cases with me where we've been in situations where people just needed a simple power of attorney to protect their loved ones, but they didn't have a power of attorney. And as a result, it turned into a guardianship application. And the way the guardianship applications work is we have to get some medical provider, either your doctor or a psychiatrist on board to say that you cannot make decisions for yourself and it's in your best interest to have somebody else designated as the person to make those decisions for you. But here's the problem. The probate court doesn't hear those cases quickly. In fact, Natalie and I were working on a case almost a year ago now where our client's loved one ended up passing away before we got into court to have the guardianship hearing, right? And so a thing that you can do right now is get a healthcare and financial power of attorney to avoid all of that for your loved ones. Like I said, the other thing that you can get is a trust. Now, a trust takes all of your assets that are probate assets and makes them non-probate assets so you avoid probate altogether. Trust, healthcare power of attorney, financial power of attorney. Looks like we might have another question in the chat, Nat. That kind of rhymes. Another question in the chat, Nat. The lawsuit was filed by the victim, for lack of a better term, and she said victim. Oh, that's a great question. So the question that we have here in the chat is kind of a follow-up to the medical malpractice question that was presented to us a little earlier. And it appears that someone had passed away and filed a lawsuit. And then, they filed the lawsuit and then they passed away. And as a result, the father was appointed as the administrator of the estate and the bond was waived. And the mother would like to know if this is proper for the probate court. So here's what I can tell you based on my probate knowledge, and Natalie will chime in a little bit as well. If your loved one filed the lawsuit, then that lawsuit has to be advanced by someone appointed by the probate court. Now, in order to be appointed by the probate court, the father would have had to submit an application to administer the estate, and the probate court would have requested a waiver from all interested parties. And if there weren't, no waivers were signed, then the probate court would set the matter down for a hearing to decide if we're going to appoint the person designated or the person who applied to be the administrator. And if you did not contest that application, then the probate court would have granted that to the person that applied, being the father. Does that make sense, Natalie?
Yeah.
Anything you want to add to that?
I've also seen, back when I was working for the court, I've seen a few cases where it was opened for litigation purposes only, kind of like this one. And the court has discretion to waive the bond themselves as well. If there was no amount known at the time what was going to be the settlement, they may have waived the bond and may have required it later if it was a significant value and maybe some other assets were discovered. But that could also be a possibility if the court waived it as well, but it could have been a waiver situation too.
Yeah, and I'm glad you said that, Natalie, that the probate court has a lot of discretion in terms of waiving the bond. And Natalie's well versed in that there's a statute that says if it's $10,000 or less, you can request that a bond be waived, or the probate court can sua sponte waive the bond. So they could just do that. And as Natalie said, in this kind of case, if there's no assets that are going to be in the administrator's hand, it makes perfect sense for the probate court to waive the bond. A lot of great questions. So here's what I want to leave you guys with. It doesn't make sense to do a lot of planning to get your affairs in order and then still have to go through probate court. if you're interested in avoiding the probate court or finding out what your rights are, then I want you to click this link. I'm gonna give you the link here. To click the link and you can talk to one of our team members. They'll be able to go over kind of the probate process and then also help you along the estate planning process so that your family can avoid the probate court altogether. You know, most families go through death maybe once or twice, or, you know, if a parent, you know, one parent dies, another parent dies, they go through that and they go through that experience once or twice, or maybe 4 times if your spouse's parents die as well. But it's a tough time, right? And one of the things we try to do is make it easy on everybody so that you can navigate the probate process. Natalie and I, we've gone through this probate process hundreds of times with clients, right? We've seen how different probate courts handle different situations. And so we want to help you guys make a well-informed decision. See, that's why I started Littlejohn Law, to help people make well-informed decisions and to help them navigate the probate court process. Natalie, any final words that you want to share with the viewers?
Sure. So this is something that I personally have gone through within the last few months. My parents are getting older and I know they have estate plans in place, but I really don't know what assets that they had, other than a house, you know, and a bank account and that. So my parents been trying to sit me down for a long time to talk about what affairs to get them in order. This is where my will is. This is this account. I have this account. It's a very difficult discussion to have, but wow, you can do it now. It's a great opportunity to do it to make your lives easier, your family's lives easier once they're no longer here and you're not trying to hunt around for assets. So trying to get those estate plans in place now, it's a great decision and it's definitely going to be a benefit to your family in the future.
Thank you for that, Natalie. And like Natalie said, it's a very difficult conversation, but it's one that you definitely need to have, because far too often we see people dealing with the loss of their loved one and fighting with their siblings over who gets what assets. So as I always say, remember, where there's a will, there's a way. Where there's no will, then there's probate. But the best plan is a trust plan. And guess what? I'm your trust man. Hope to hear from you soon. Bye.